Hello friends, this is Sanjay. In this video series, we will cover the interpretation of statute subject from the LLB syllabus of Chaudhary Charan Singh University or CCSU, Meerut. The syllabus is common for both 3-year and 5-year LLB programs. The complete playlist is available on the Lawment YouTube channel. While I have covered all the topics that are specifically mentioned in the syllabus, I have also included some additional concepts and topics which are required for a better understanding of the subject and also helpful if you are preparing for any post-LLB exams like the CLAT PG, UGC NET or Judicial Services. The timestamps for the specific topics as per the syllabus are in the description below. This is part 6 and we will cover maxims of statutory interpretation. What are maxims? Well, you already know why statutes may sometimes need interpretation. If a statute is clear and there is no confusion, it should be implemented as is. If there is some confusion or ambiguity, that is when interpretation is required. To interpret a statute, the courts will first apply the primary rules. If required, the secondary rules are applied to fine-tune the interpretation that has been reached after applying the primary rules. And of course, presumptions are applied at every stage of the interpretation and the implementation of the statute. Now, what are these primary rules and secondary rules? The literal rule, the golden rule, and the mischief rule or Hayden's rule are usually considered to be the primary rules, and all of the rest are considered to be the secondary rules. Within these secondary rules, there are these rules in Latin language, like Ejusdem Generis, Noscitur, sociis, Raddendo, singulis, casus omissus. These secondary rules, which are in Latin language, are also known as maxims of statutory interpretation. Why are these maxims in Latin? If you look at the development of modern law, including Indian law, it was not invented from a scratch. It has developed and evolved over several thousand years. Now, Indian law is mostly based on the legal system that was being used by the British. The British legal system, in turn, evolved from the ancient Roman legal system. These Latin maxims are principles and concepts that were originally developed and were in use in the ancient Roman system, and they were adopted by the British, and they eventually became part of the legal system of all the common law countries like India, United States, Australia, Canada, etc. So, in short, maxims are also secondary rules of interpretation of statutes. The only difference is that these maxims are in Latin language. Ejusdem Generis is a Latin term that translates to of the same kind or nature. Ejusdem Generis is a rule which says that if there are general words following particular and specific words, then the meaning of the general words must be confined to those things which are of the same kind as those specified, unless there is a clear indication of a different intention. For example, if the law says that the storage and sale of rockets, flower pots, sparklers and other articles is hereby banned, then the interpretation of these general words, other articles, must be confined to the same kind as the specific words. Since the specific words, rockets, flower pots and sparklers are fireworks, then the interpretation of these other articles should also be other fireworks. Then this rule is essentially saying that the storage and sale of rockets, flower pots, sparklers and other fireworks is hereby banned. If the Ejusdem Generis rule is not used, then this term other articles can mean any other articles. It may be clothes or decorations or puja articles which are not fireworks. So this rule will essentially prevent the person from storing and selling anything and everything, which would be an injustice. On the other hand, if the intention of the statute was to ban the storage and sale of everything, then that should have been clearly clarified in the statute itself. To apply the rule of Ejusdem Generis, the following conditions must exist. The statute must have some specific words like rocket, flower pot. The members of the enumeration, that is, the specific words, constitute a class like fireworks. The class is not exhausted by the enumeration, that is, there should be other items in that class apart from what are listed in the statute. Like there are several other types of fireworks other than rockets, flower pots and sparklers. A general term must follow the enumeration or the list of specific words. Like here, other articles is a general term that follows the specific words. There is a distinct genus which comprises more than one species. In simple words, all of the fireworks can be put into a single class or a genus. There is no clearly manifested intent that the general term be given a broader meaning that the doctrine requires, which means that the statute does not clearly indicate that the scope of these words, other articles, is to cover articles other than fireworks. If all of these conditions are met, then the rule of Ejusdem Generis can be used. Noscitur a sociis is a Latin phrase that means it is known by its associates. This rule says that while interpreting a statute, the meaning of a word in that statute should be known from its accompanying or associating words. For example, if the law says that throwing trash into lakes, rivers, streams and other bodies of water is a crime, and there is a need to precisely decide the meaning of this other bodies of water, that is where the Noscitur a sociis rule can be used. Since lakes, rivers and streams are natural bodies of water, this law can be said to include the sea as well. So, throwing trash into the sea is also a punishable crime. However, a swimming pool, although it is a body of water, it is not a natural body of water. So, swimming pools are not covered under this law. Another principle to remember in the context of this rule and other rules is that the same words will bear the same meaning in the same statute. Once you have decided as to what is the meaning of these words, other bodies of water, that meaning will apply wherever these words have been used in the same statute. You cannot keep changing the meaning of the words from one part of the statute to another. Unless, of course, there is a context as to why the meaning should be different in different parts of the same statute. Or there is a proper reason for changing the meaning. Or if using the same meaning in different parts of the same statute is causing some absurdity or injustice. Or if there is a different circumstance that is being dealt with in a different part of the statute. Or if the same words have been used in different contexts in different parts of the statute. You may also notice that this rule, Noscitur a sociis, is similar to the rule of Ejusdem Generis. Well, there is a difference. The Ejusdem Generis rule is applicable in situations where the words used in the statute are more general. Like if this law said that throwing trash into lakes, rivers, streams and other places is a crime. The words other places is very generic and the Ejusdem Generis rule can be used. But here the words that are used are more specific, that is other bodies of water. So the Noscitur a sociis rule can be used here. Expressio Unius est Exuclusio Alterius. This is a Latin maxim that translates to the express mention of one thing implies the exclusion of another. The two conditions which need to be fulfilled cumulatively in order to apply this maxim are as follows. Firstly, the list of words appearing in a statute should be specific in nature. And secondly, those specific words should not be followed by general words. Then the act or the legislation will only apply to the specific words appearing in the list. For example, if there is a board which says car and bike parking 8 am to 10 pm. Here, both the conditions are fulfilled. The statute has a list of specific words, that is car and bike. These specific words are not followed by any generic words. So, the rule in this case clearly applies on the list of specific words, which means that only cars and bikes can be parked here, that too between 8 am to 10 pm. In the second board, it says car, bike and vehicle parking. So, the first condition is met. There are specific words, car and bike. But the second condition is not met, since there is a generic word vehicle after the specific words, which means that cars, bikes and any other vehicles can be parked here from 8 am to 10 pm. To recap, the rule says that the express mention of one thing implies the exclusion of another. So, if a statute mentions a list of specific words and there are no generic words that follows them, then the statute will cover only the specifically mentioned words and exclude everything else. The advantage with this interpretation is that the statute will clearly focus on what is expressly mentioned in it. The disadvantage is that it may lead to a very narrow interpretation, which may not be ideal, because the real intent behind the law may not be met. Raddendo singula singulis is a Latin maxim that means let each be put in its own place. This rule says that when a sentence in a law has several parts, then each part should be interpreted in connection with the words that are closely related to it. For example, if the rule says that interfering with the work of firemen, policemen and doctors in a hospital is prohibited, there are several parts in this sentence, and each part should be interpreted in connection with the words that is closely related to it. In a hospital is closely related with the doctors, so this should be understood as interfering with the work of firemen, or interfering with the work of policemen, or interfering with the work of doctors in a hospital is prohibited. If the Raddendo singula singulis rule is not followed, then the sentence can be interpreted as interfering with the work of firemen, policemen or doctors in a hospital is prohibited, which means that interfering with the work of firemen or policemen or doctors outside a hospital is not prohibited. This does not make sense, does it? The advantages of this rule are that there is precision in interpretation and it avoids generalization. And the disadvantages are that this may make the process of interpretation more complex, and there is an over-reliance on the text of the law rather than the intent. So, imperfectly written laws may be interpreted imperfectly. Ut res magis valeat quam Paraeat. This is a Latin term which means it is better for a thing to have effect than to be void. This rule is quite simple. It just says that when interpreting an unclear statute, the interpretation that gives effect to the statute should be preferred over one that invalidates the statute or makes it meaningless. For example, if there is a board which shows the pictures of a bike and a car and mentions that they are banned in a school zone between 8 am to 4 pm, does it mean that only cars and bikes are not allowed, but buses, trucks, autos, tractors and other vehicles are allowed? Since the real objective of the signboard is to ensure the safety of the children who may be walking in and out of school, it doesn't make sense to interpret this board to say that only cars and bikes are banned, because even fast-moving trucks, buses and autos may cause accidents. So the interpretation that best suits the intent of the rule is that all traffic is banned in the school zone from 8 am to 4 pm, and the board is only showing the pictures of a car and bike as examples, because putting icons of all vehicles is not practical. The advantage of this rule is that it makes laws more effective. At the same time, a disadvantage would be that the interpretation depends a lot on the discretion of the judge, making it very subjective. And there is also a possibility of the law being extended much beyond its intended scope. For example, what if the actual intention of this restriction was only to ban cars and bikes, and it is the interpretation that is extending it to all vehicles? Casus omissus is a Latin phrase that means a case omitted. It refers to situations or issues that have not been specifically addressed or provided for in a statute. This can be either because the situation itself was not anticipated when the law was written, or it has been left out by oversight. The general rule is that if there are significant gaps in a law, then the court cannot fill these gaps with its own interpretations. For example, when cryptocurrencies started becoming popular in India, then there were no rules or laws that specifically governed how these cryptocurrencies could be bought, sold or exchanged. Then there were some situations where there were some disputes, but these situations were not covered under the existing laws, because the existing laws did not anticipate the unique requirements of cryptocurrency related issues. Here, the judges should not try to plug the gaps through their own interpretations. It is up to the legislator to decide as to how they wish to address these issues around these new technologies and create appropriate laws. This rule has been reconfirmed by the courts in some landmark cases, that the judges should interpret the law as is and not attempt to fill significant gaps in the statutes in the guise of interpretation. Since the basic idea here is to interpret the law as is, the advantages will be certainty or predictability, and also in ensuring that the process of creating laws is left to the legislature. The disadvantages are that this makes the laws rigid and there is a over-reliance on the legislature, leading to relatively straightforward situations not being addressed, just because there is no specific law in place. Ubi lex non distinguet, nes nos distinguere debemos. This is a Latin maxim which translates to where the law does not distinguish, we should not distinguish. In other words, if a law is written in a very generic manner that may cover a wider range of subjects or situations, then the judge should not create distinctions while interpreting the law. For example, if a notice says that vehicles are not allowed inside the park, it is using a very generic term vehicle. And if no distinctions are created, this notice is simply prohibiting any and all vehicles from entering the park. This is also a good example to understand how the primary and secondary rules of interpretation are applied. First, the golden rule is applied to interpret the meaning of the term vehicles to include only motor vehicles. After which, this secondary rule is applied. Since this board is not saying that cars are not allowed, or buses are not allowed, or motorcycles are not allowed, the law by itself is not creating any distinctions. As per this rule of interpretation, the judge should enforce the law as is, and not interpret it to create distinctions between different types of motor vehicles. Since the law is being interpreted as is, there is consistency, there is simplicity, and possibly fairness, since all the subjects, that is, cars, bikes, buses, etc., are all being treated equally. However, the disadvantages are that there is no flexibility, and it can lead to situations of injustice, since this approach does not distinguish between personal use vehicles and commercial use vehicles and public transport vehicles. With that, we have come to the end of this part. If you have any questions or feedback, post a comment below. Thank you for your like, share and subscription. I will see you soon in the next video. Take care and Jai Hind.